You are leaving everyday reality and entering the court gallery. Well, ladies and gentlemen, another day has passed. More court has come and gone, and I have put together a compilation of some of the best court cases that have happened today in Judge McNally's room and Judge Simpson's room. And I'm going to just go ahead and warn you. The Judge McNally block, it's just chock full of crazy. There's just no other way to put it. It starts off a little weird and gets all out bizarre before the end. The Judge Simpson is a compilation of a lot of cases that have nothing to do with what we really need to be watching on the screen. There was one individual in Judge Simpson's room today who just could not find it in her heart to behave like she was in a courtroom and on Zoom. And ladies and gentlemen, the bizarre behavior just doesn't end with McNally. It extends all the way into Judge Simpson. And we're going to be observing what may or may not have happened in Judge Simpson's court today. For more information, as always, check out the description. There's time codes. There's little snippets about what the cases are going to be about and all that type of good stuff. Ladies and gentlemen, I am your lone wolf Usul, and I bring you these court cases. It's all good, and it all starts right now.
Tyler Collins, 25B149-7738. Good morning, Mr. Schwab.
Good morning, Your Honor. 30720. We have Mr. Collins.
I also have a B file here. He pled under 7411. That is the possession of a controlled substance, which is cocaine. And he also pled on the drunk driving to the charge of operating while visibly impaired. He was referred for a screening and assessment. Have you had a chance to review that with him? And are there any material additions, corrections, or deletions?
I had a chance to review with him. I thought that the drug case was marijuana.
Wait a minute. No, I don't think so.
I know you.
They found it prints out possession use of a controlled substance, but this is the one where he acknowledged to the police that he had cocaine in his pocket.
Well, I wasn't the original attorney.
Am I right or am I wrong, sir?
You're right.
Did I ask you your name yet?
No, name's Devin.
Okay, so it was the cocaine, and he was referred for a screening and assessment. Have you had a chance to review the
I have, Your Honor.
report? Any material additions, corrections, or deletions?
You just be back to the editor.
Okay. Anything that you would like to say on his behalf?
Just, Your Honor, that I believe that he has tried to address the problem. He's gone to the A meetings. He has abstained from any alcohol and drug usage. He's a working man. It's a little light working during the winter time. He does catch some things.
Okay.
And so
He's spending all his money on cocaine, though. What's he doing? Go ahead. I'm sorry.
I think that he's right now he's saving a lot of money because he's not doing it.
Well, that's good. That's good. Mr. Collins,
Yes, sir.
what would you like to say? Anything?
Not really, just I apologize for my.
Don't apologize to me. Apologize to yourself. You know what I mean? You're a nice looking kid. You seem to have a lot going for you. Get away from that stuff. And the marijuana too, right? I mean, come on. Don't do this to yourself. I hate to see kids like you or anybody, frankly, get themselves in trouble. You just seem like you got a lot going for you, and that cocaine is miserable stuff. Did I let you finish? I'm glad to listen to anything else that you'd like to say.
I do have my 2 month coin from AA. I've
Fantastic.
been going 3 times a week. Basically, ever since the arrest, I've been mostly clean as a whistle, basically up until about 2 months ago. So
Wait a minute, Chase. Say that again. The offense was in October. We didn't have a pretrial on this till December 18th. What do you mean? I thought I heard you say I was clean as a whistle up until 2 months ago.
yeah, after the arrest, I was still smoking a little bit, and
I see.
then after about 2 months ago, I was going to stop altogether.
All right. You have proof of your AA attendance? Can I see it?
There's 2 separate ones because I misplaced one of them. So there's a couple on, there's mostly on one of them and a couple on another.
All right. Who do you live with?
Myself.
You own a house? You rent a house?
I live at my grandma's old house and paying off her mortgage right now. I'm living there.
Okay, don't lose these anymore. I'll take it your word. I'm gonna hand you these back. Can you approach Mr. Schlaffel, hand those back to him?
Yeah.
And he's going to stay out of trouble. I know he is. Right, Mr. Collins?
Yes, sir.
All right. 12 months probation. On file A, it's not under any statute. In other words, there's no 7411 or anything else, but it is on the B statute. So if you're clean, you do everything I tell you to do, that's count 2 on motion to prosecutor is going to be dismissed. Because I'm taking it under that statute. You understand that, right?
Yes, sir.
So 12 months probation, all these terms are going to run concurrent. You cannot leave the state without the consent of the court. You cannot violate any law or ordinance. If you change your address, your place of employment, or home telephone number, you must notify probation immediately. You have to report as directed. No alcohol, no marijuana, no illegal drugs. You're not to purchase, possess, or consume any one of those things. I do want you submitting the chemical, kratom poppy seeds and CBD oils are prohibited, by the way. Consuming food or other items containing those substances will be deemed a violation. You're to submit to chemical testing, PBTs and ETGs bi-weekly. The cocaine has me even more concerned than the other. You're going to do that for 5 months. If you're clean, I'll then make it monthly. So every other week, you're going to test, and I expect you to test, okay? We want to make sure you stay off of that. You understand?
Sure.
All right. 4 days jail, credit 1, serve 3. I'll let you serve all of those on the court work program. There's a $35 a day charge for that for a total of $105. Again, I'm attributing the fines and costs primarily, unless they say otherwise, and all the common costs on file A. So you're also to attend and complete an outpatient substance abuse treatment program. You're going to continue going to AANA 3 times a week until you're until you're in outpatient treatment. And you are also to attend the victims impact panel. So the quicker you get in outpatient, the better. If you get in this week, you no longer have to go to AA or NA, but you do have to complete outpatient treatment. You do have to attend the victims impact panel. Do you understand everything I've said so far?
Yes.
All right. In terms of fines and costs, on the A file, the impaired file, $300 fines, $250 costs, $75 victims' rights fee, $50 justice assessment, $675. Screening fee is $60 for $735. Probation fees are $240 for $975. You have cost of recovery of $218 for a total of $1193. I'm gonna just assess $40 in attorney fees for a total of $1,233 plus the court work program fees of $105 for a total of $1,338. I'll go light on your fines and costs on the other case. It's simply going to be 100 fines, 100 costs, 75 victims' rights fee, $50 justice assessment. The screening fee, probation fees, cost of recovery fees are all going on the A file. So you owe 325 plus 1338. That would be 1663. You have 21 days to appeal, 14 days to apply for a court-appointed lawyer for purposes of appeal. And you may be eligible for early discharge, certainly on the impaired, and the prosecutor certainly can move to dismiss the 7411 if he is satisfied once you file your motion for early discharge on the A file.
Your Honor, if I may.
Sure.
Is it possible for him to do some extra community service in lieu of some of the costs?
You can't pay these fines? I mean,
During the winter, I work like a part-time job because my job is seasonal, so.
here's what I'm gonna do.
After the time during.
I'm gonna let you pay $50 a week. And I'm gonna do that on the A file. And I'm gonna start that beginning on February the 27th. I'll give you a little bit of leeway time. So I'm gonna only have you pay 50 per week starting that date. If you need more time, you can come talk to me. After you pay the fines on and costs on that, you're gonna pay on the B file. So after fines costs paid on the A file, you'll pay them on the B file. If you're really running into trouble, you come back in here, file a motion. I'll be glad to entertain that request for you, okay? I'll give you a review hearing date right now, which is going to be 12 months out on the 7411, the drug charge. What do you have for me there, Amy? It should be in January of 27, God willing, if we're all here, Mr. Sloth.
Very good.
It's going to take her a minute. That's the next year's calendar.
January 27, we can do the 14th.
14th is good. January 14th at 8:30 in the morning, okay?
Yes, sir.
Now, that's independent of the other case. So if you do everything, there's no violations, you feel free to make your motion for early discharge in 6 months on the impaired charge. And usually the prosecutors will then go ahead and move to dismiss on the other, okay? I wish you well. Thank you, Mr. Schlaff. You're going to meet with probation before you leave here, okay? Thank you. Derlin Wright. Derlin Joseph Wright, 25R 514-323-25F 244-059. Mr. Wright, how are you? Your name?
Carmen B7324, I'm at the depending, Your Honor.
All right. So we got a $100 cash bond on the civil infraction that I set, and also a 10% bond on this misdemeanor. So he's been in custody since I did that back on January 27th. So he has 2 days credit coming from that. He was referred for a screening report. Have you had a chance to review it with your client? And are there any material additions, corrections, or deletions?
Your Honor, I've had the chance to review that link with Mr. Wright, and I'd like to bring the court's attention to a couple things. Regarding employment, he is working full-time as a laborer. The name of the company is Wheel Deal, WHL Deal. That is in Flat Rock, here $20 an hour. He does now have a 3-month-old daughter, and they all live with his parents in Flat Rock. And as far as his health status, about 2 weeks ago, he was in a serious car accident, so he suffers nerve damage in his spine, and he's currently on arthritis pain relief due to that. Mr. Wright has been in custody for 3 days. I've gone over the recommendations of probation with him. He understands what he needs to do, and would ask that the court adopt those, please.
Anything you would like to say?
Like my lawyer basically said, basically about something. That's basically everything. That's I was going through.
I can't hear you.
My lawyer basically got everything I'm going through.
Why are you doing this to yourself? I do not want you to say one word admitting or denying what I'm going to say. Weren't charged with it. They didn't have enough evidence. But when I read this report, I can say to myself, these guys were going to break into cars. Don't say anything. You can't do this. You can't do this. I mean, you can do it. And then you're going to get caught. And then you're going to go to prison. And you'll note that I said prison, not jail. Prison. You know what I mean when I say prison, right? You know, yes?
Yeah.
You know why you know that? You know why you know that? Tell me why you know that.
Family has been very.
Well, because you've been around the system too. You got a felony going on right now, right?
And then,
Mr. Right. It's your life. It's not mine. It's not your lawyer's. It's not anybody else's. I've seen this movie. All it is a replay. Sometimes the movie gets uglier. Sometimes it takes longer to play. I've just seen this movie, this picture, hundreds and hundreds and hundreds, if not thousands and thousands of times. And I'm pretty good at predicting. And I'm telling you, the way you're acting, you're not heading to jail, you're heading to prison. Now it's your life. Again, I wouldn't want to go there. Remember when I was a young lawyer going into the Wayne County Jail with some of those guys, they stunk, their breath stunk, and I had to talk to them. In a cubicle about 5 by 4. Everything about them stunk. You want to go to prison with those type of people? Continue on this little journey that you're on. I'd like to see you turn it around. How old's your daughter?
3 months.
How great that would be if she's 6 and says, well, my dad, I haven't seen him 3 years, but I'll see him when I'm 21. He's in prison. You can do that if you want. You struck me as being a nice kid who's doing bad things. You're sleeping with the wrong friends, son. And I don't mean literally sleeping. You're hanging out with the wrong kids. Maybe you're the leader. I don't know. Maybe they're following you. Who knows? The first thing you need to do is go back and get a GED or a high school diploma. I don't know how anybody gets a job that's worthwhile if you don't do that. You don't have any learning disabilities, do you? So you just didn't study at all in high school, right? You just didn't try, right? Right?
Well, that wasn't it. I ended up going online. Then I had ended up leaving by the end of the year to go work full time.
Yeah, but why were you going online instead of going in person? Whenever somebody tells me they went out online, you know what it tells me?
Yeah.
I'm going to take the easy way out. I mean, there's a lot of things we can do to take the easy way out, right? I think so. You know, you can watch anything, any profession, any sporting. I don't care what you're watching. A lot of people take the easy way. It's easier to take the easy way out. I want you back in school. I want you getting a high school diploma or a GED. I want you staying away from these people that you're hanging around with that are wearing masks and trying to break into cars at night. You got me? Don't admit anything. Go to work. You're young. You're strong. I can tell by looking at you. You can work 65, 70 hours a week.
Good.
These are prime earning years for you. You get old like me and just me in here, then it gets tougher.
Sure.
You got it?
Sure.
All right, let's get you back on the right track. 12 months probation. This is all on the open intox. I'm going to try to not do all this because I know I'm going to be watching you not comply.
But
Listen, I want you to be one of those guys that writes me a letter in 2 years and says, "Thank you, Judge, you helped me." That's what I want. You want to do that, or you want to just end up in prison?
trying to reach back, let you know what you live.
12 months probation. You cannot leave the state without the consent of the court or violate a law. Change your address, place of employment, or home telephone number. You must notify probation. You have to report as directed. No alcohol, no marijuana, no illegal drugs, no violations of law. We understand that. Kratom, poppy seeds, and CBD oils are prohibited. Consuming food or other items containing those substances will be deemed a violation. They want you to test bi-weekly for 12 months. I don't, because I know you're not going to do that. But I am going to make it bi-weekly for 3 months. And if you're clean, then I'm going to make it monthly. You got it?
Thank you, Your Honor.
Then I'm going to have you go to AA. I know you probably weren't doing it before on December 11th. You didn't go to AA, did you? When I ordered, you didn't do that, did you?
But
Yeah, I'm just asking you a question.
no,
Did you?
I didn't go.
Yeah, I know you did. You didn't go because I know you didn't go. I know because I just know. We're going to give you another form. You're going to start going. And you're going to that until you're in outpatient treatment. Once you get in outpatient treatment, you no longer have to go to AANA. So do we understand each other so far? All right, you spent 3 days in jail. I'm going to give you 3 days credit. I'm going to order 5 days jail, and I'm going to let you do the other 2 by way of the court work program. You know why I'm doing that? Because I'm going to trust my little conversation with you is going to help you reflect and think about where you're going with your life. You're only 19. You got 75 years ahead if you want it. It's nice to see you smiling. 2 days court work program in lieu of jail. So I'm going to release you on this case as far as this case is going. $70 in court work program fees. You have to clear all your warrants. Now that's going to take money. They want it to be done in 30 days. I don't think you can do that. I'm going to give you all the way to April the 1st to do that. I'm going to assess fine. I'm going to go light on your fines. Fines 100, 75 costs, 240 in probation fees, $75 victims' rights fee, $50 justice assessment. All that's $540 of a $60 screening fee for $600 and court work program fees of $70, your total $670. If you violate, you could get 90 days. If you comply, you're eligible for early discharge in 6 months. And you know what I'm going to do for you, Mr. Wright, just so I can get you off to the right start? You owe $210 on file 25R514323. I'm just going to make a note. Defendant spent 3 days jail. I'm going to waive the balance of those fines. How nice is? Well, it's all for naught if you don't do that. Remember, I'm also ordering you to get a GED or a high school diploma. You're doing that for you, for your daughter. You realize your daughter's like 100 times more important to you than you are, right? So you got to raise a good daughter here. All right?
Yeah.
Come on now. I don't want to see you back here. Except to ask me for early discharge. Please don't come back and see me. I'm going out of my way here. What's that?
So you started leaving.
Get that diploma. Stay out of trouble. Life's a lot more fun. Work. Burger King, McDonald's, on top of your other job. I don't care where you go. Go to a hardware store. I don't know where you go. Good luck.
Thanks.
Oh, by the way, I got to set up a payment plan, don't I? Wait a minute. I'm sorry. Come on back here. Mr. Wright, I'm going to let you tell me how much you can pay and afford to pay and when. How's that?
Me and my lawyer talked about 150 a month.
I don't want 150 a month. Okay? I don't think you can pay 150 a month right now.
But the duration of the whole probation, 36 months.
You owe $670. I'm going to let you pay $65 monthly, beginning March the 1st. But I'm not going to discharge you unless you have it all paid, with all money due by November 1 of 26. Okay? Got it? You need more time? What are you going to do?
Contact you, my brother.
Contact me. You can either come in here on or before the due date at 8:30, or you can call the court, go on Zoom. Was there something else I needed to address?
Further ground.
Good luck. Stay out of here. Okay?
Thank you.
You're a nice kid. Act like it. All right, Ms. Matejzek, I hope you're, I can't do much for her, Mr. Dabolski. Courtney Elaine Matejzek, 25R724360.
Good morning. For the record, Brendan Dabolski, on behalf of Courtney. Yes, and Christine.
Ma'am, your name? So let me start by saying here that, and she's off the Adderall now, right?
Correct.
It looks like you're doing good on bond. The prosecutor's office has consistently said 60 to 90 days. I've argued with them over the language. They've left it to my discretion. But there's no way I can justify not sending you to jail today. I'm going to listen to what your lawyer says. I'm going to do the best I can for you, but this is a third. And even though you're getting in sobriety court, that will help you tremendously. But there's no way I can rationalize not doing that in my brain. So with that, and we have elected to admit her. So with that, Mr. Dabolski, have you had a chance to review the report with her, and are there any material additions, corrections, or deletions?
No, we reviewed it and there are no additions, corrections or deletions.
All right. What would you like to give me your excellent words of wisdom, as you always do, so I can do the best I can for her here?
Well, thank you, Your Honor. With that being said, before I dive into all her redeeming qualities, I just want to remind the court, yes, this was reduced from the prosecutor's office. And with that being said, Your Honor, I know that you said it's hard for you to deviate your mind from the jail time, but I
didn't say it's hard for me to deviate from the 60 minimum days. I'm not saying that. Go ahead.
Well, I was going to just remind the court that according to the plea agreement,
I know, I completely.
Your Honor could waive all.
Exactly.
It's
I know.
all within your
No, I know that. I know.
So,
For the longest time, they sent me minimum 60 to 90 with work release if eligible.
right.
And then it was if they do anything wrong at all or they don't make it through, I have to give them a year. And I fought with them because they're not the judge on the probation violation sentence. I am. And I don't mean to sound uppity about it. I just mean prosecutor's office should not be telling judges what to do in the event of a probation violation. I fought that war for years and I finally got it where it's reasonable. But she's got 3 offenses. She had a 2-3. She's the ripe old age of 34 years old. And that's where we are. So go ahead. I'm going to listen intently. I promise you.
Standing before the court, my client is 34 years old. Okay, she does reside in Farmington Hills. She's here today with not only her mother that's seated directly behind me. I believe it's in the second row. But behind her, there's 2 individuals. Number one is her sponsor. So she's taken it upon herself to obtain a sponsor. And not only that, there's an individual seated next to the sponsor that is in charge. He's very involved in AA. I think this court, city's dealt with this court in the past. He's familiar with this court.
Mr. Wells, who got through the sobriety court. I'm really, really, really proud of him. So proud of him. We put him as a supervisor on our court work program.
Oh, and that's a testament to how well he has embraced sobriety.
He's done. He gave me some gray hairs and some fits, but yes, he did. Yes, he did.
Well, he's taken it upon himself to stick his neck out on the line for my client. My client, from the very beginning, obviously there's bond conditions. My client has complied with those bond conditions. Your Honor made reference to that. She's an individual, first and foremost, Your Honor. The reason why she's getting into sobriety court is because she has a problem with alcohol. Okay. Yes, there were 2 priors. She was charged with a felony. On this 3rd offense, it was reduced. She was given a break. It was reduced to a 2nd offense with sobriety court. She got it. Let me remind you, and I'm not saying that in a disrespectful way, but Your Honor, I had brought it to my client's attention that when she was working out here at the time at Leo's Coney Island, I guess on the report it indicates that she is employed there. She kind of is, but she's not working right now. She's on leave from there, so technically she could go back, but she's taking a leave of absence to focus on her sobriety, which she truly needs to. So with that being said, she's taking it upon herself to not only attend 8 a.m. 3 times per week, which no,
I believe you.
feeling you trust me.
You don't have
but
to show me. I believe
I do
you.
have proof of all that. She's involved with an individual therapist once a month. She, she obtained the sponsor. Okay. She's doing IOP right now, which she's in compliance there. She has really kind of, for lack of better terms, grabbed the bull by the horns here. And she has embraced the fact that she is the type of person that can't drink, not just for this period of time while she's in sobriety court, while the case is pending, but for the rest of her life. She has gotten sober in the past, Your Honor. However, she was, like many of the individuals that are in that situation, they think that, if you just slowly go back and you don't drink as much, you don't really have an issue with alcohol. She'll be the first one to tell you she's an alcoholic and that she can't ever drink again the rest of her life. Matter of fact, we've spoken at like many times throughout the duration of this case, and she has indicated that, it's not her friends that she's blaming for getting into trouble, but the people that she was running with just weren't people that were helping her in life. Matter of fact, now that she's sober, she's come to grips with the fact that sadly, these people probably weren't true friends because now that she's not frequenting bars, hanging out and drinking at parties, they're not involved in her life. And she realizes that those aren't the type of people that she wants to surround herself with anyway, because she has lofty goals to turn her life around. She has been spared a felony conviction on her record, but most importantly, she's going to remain sober. She knows not only for just sparing trouble in the future, but for this case, she could go to jail for up to a year, but just to get her life back on track. I'm not using this as an excuse, Your Honor, of why she relapsed. I kind of want the court to understand what was going on at the time. And it's, like I said, it's not an excuse. She'll be the first one to admit that she chose to drive the car on the night in question. Thankfully, there was no accident. Nobody was injured or even worse, killed. The police officer actually pulled her over prior to, her driving. She ran out of gas right on the road. But nevertheless, with that being said, she has taken a positive approach to this. She even indicated to me that this is kind of crazy to hear this, but it's the best thing that could have happened to her. And the reason why is because it caused her to realize that she's not one of those people that can just drink, once in a while. She can't drink at all for the rest of her life. And Your Honor, just like that speech you gave that young man, 2 people before me, before my client, she's in the same boat. If she goes back to drinking, she's going to be like that gentleman if he doesn't clean up. She's going to end up in prison. And that's what happens when you can't identify, problems in your life. And she has to understand what her triggers are and obviously remain vigilant against those and stay sober. And I think this program is truly created for individuals like my client who have a problem, who want the help, who are going to actually gain something from getting that help. And I have no doubt in my mind, I'm standing up next to this young lady right now, and I've known her for a long period of time, but I have no doubt in my mind that she's going to do everything Your Honor orders her to do. I know that she was ordered by the probation department to refrain from taking the Adderall. She has stopped taking that Adderall, as Your Honor had indicated.
But she got clearance from her physician, right?
She did.
Because we just won't accept anybody, but probation, we stand very short of telling somebody you got to get off of medication. We only say, if the doctor thinks you need it, fine, but we can't accept you. So I just want to clarify that into the program. You follow me?
100%.
Okay, go ahead. I'm sorry.
I mean, she doesn't think it works as effectively as her new medicine as effectively as the old, but at the end of the day, this is what she wants. She really wants us to go there. She wants you to allow her into it. However, one thing I will say, unbeknownst to Your Honor, I wouldn't bring this up, but I think that, considering that, she's an individual that has a problem with alcohol, yeah, if she was on bond, if she went back to drinking, Your Honor would throw her in jail, and it wouldn't really solve the problem. She could do, roughly, do her probation, 30 days in jail downtown if it didn't get reduced, and be gone back, back doing what she wanted to do. She didn't want to go that route. She was fortunate to get this. And during the inception of this case, she's dealt with a lot. I have a letter from her doctor right here. Unfortunately, she has some pretty serious health concerns. They just detected.
Hand that up.
Yeah. It doesn't state everything, Your Honor, but I will say, yes. Your Honor, at her last doctor appointment, they detected some
Some like high-risk cells that,
I see. You don't have to talk about it.
correct, but long story short, surgery is required. So,
I'd like to have a copy of this for the probation file.
something that's pretty serious.
So I want to make sure that you take this back, but I'm going to have a copy of this in the probation file. Go ahead.
Needless to say, I'll summarize it. It's a very serious medical condition that requires surgery. Obviously, thankfully, Your Honor, is caught early. But I know that, Your Honor sees this as someone that has to be punished because of, the number of offenses. I'm asking this court to deviate, give my client a chance. She understands, Your Honor, that if for some reason you were able to see it that way, any violation, I'm so confident she's not going to violate. I'd say any violation, give her what you would typically give someone in this situation. But I think because she's gone to great lengths to prove, not only, no offense, not only to this court, but to prove to herself and her family that she can do this.
She got through the 35th District Court Sobriety Court program in 15, right?
Correct.
Did you graduate? That scares me, though. In a lot of ways, it scares me that was a second offense. You did that, you came out, and we're going to take a chance on you again. I don't usually put people in a sobriety court on when they've already done it, at least in ours, but I happen to think that we do pretty good with this. And I'm only saying, go ahead.
Well, Your Honor, I don't want to cut you off. One thing I sometimes get sidetracked, but what I was saying is, I don't want to use it as an excuse, but what her mindset at the time was, is that her best friend in this world was her grandfather. And right before this incident happened, she had watched her grandfather's health rapidly decline. As a result of that, in order for her to cope with seeing her grandfather's health decline, she would use alcohol. She used it excessively. And thankfully, nobody was ever injured when, she was driving that day. But right after this incident happened, as a matter of fact, her grandfather passed while she was in jail. Took a huge toll on her. Clearly, she's emotional now. You can see how much that, just passing of that individual has affected my client. Thankfully, she didn't resort to using drugs or alcohol to cope with the loss. She did use alcohol to cope with continuing to decline in health. But, she's firmly committed to doing everything Your Honor orders her to do. I would ask, Your Honor, not to give her any jail time, allow her to do the probation, allow her to do work program. In lieu of that, she has another issue with some spots on her face that the dermatologist has to send out because he's concerned about issues there. She's going through it right now. And I would just ask you to allow my client to prove to this court that she's taking this matter seriously and that, any violation, Your Honor, give her what you were initially thinking of giving her today, but to take a flyer on her and allow her to prove that she is an ideal candidate for not only this program, but to prove to you that she's going to do everything this court orders. She's not doing it just to, pacify you. She's doing it because she wants to help and she's a new person. I would ask you to, take all those statements into consideration and obviously avoid the jail time. But my client does want to address the court herself as well before Your Honor.
Sure, go ahead. Take your time, relax. Do you want a Kleenex or something?
Can I grab one?
Sure. You got them around here somewhere. Right there. Right here.
Thank you.
I just want to take a moment to, tell you thank you for giving me the chance to do this. And like he was saying that, I did resort back to old ways because I was his medical advocate. It was hard to watch him pass. It was hard to watch him get sick. And, I'm sorry to cry. But
You're fine.
I was scared. Before it happened, I was scared of how I would drink after it happened. And like, this is a blessing. I feel like, it happened to me that way. I couldn't be sober when it did happen. And, I was sober. I've been sober since incident. I was released on the 13th. My grandpa passed on the 14th. I was able to be there with him. I was able to withhold my promises. I do take full accountability. I understand what I was doing was wrong, and I didn't know that there were consequences. And I just really feel like things have been, I've been blessed to have this opportunity, and be there to honor his wishes and his last moments, and and then the therapy, the AA, it's doing well. I've met great people. I've been attending the meetings. I met Brett there, and then I had the impression that just the way he carried himself, and that I seen him here, and I was like, wow, like it just really inspired me. And I met my sponsor at another meeting, and I attend as much as I can, and it's just been beneficial. And on a lot of that, I was lacking with my own health concerns. So these last few months, I've been able to take a lot of things on that I wasn't really concerned about while I was medically advocating for my grandfather. And I do appreciate everything you guys are doing here, and allowing me into the program, and different opportunities to move forward. And I do see that remaining sober is beneficial in my best interest, because when I didn't drink with my recent diagnosis, and I didn't drink alcohol, and when my grandpa did pass, and I really have seen no way of life, and that it does just cause me more problems than it does help. And
You were in custody for one night at the time of this arrest. Is that true or false?
Correct, Your Honor.
Some lawyers think this job is easy, Mr. Polsky.
I would never think that, Your Honor. I mean, makes some difficult decisions every day.
24 months probation. You cannot leave the state without the consent of the court or violate any law or ordinance. If you change your address, place of employment, or home telephone number, you must notify probation. You have to report as directed. No alcohol, no illegal drugs, no marijuana. You're not to purchase, possess, or consume any one of those. You're not to go to any place where drugs are being sold or dispensed or used. You can go into a drugstore. Those are drugs, but that's not what I'm talking about. You can't go to parties. You can't go to drug parties. You can't go to bars. I'm not going to consider it a violation if you walk into a 7-Eleven because they sell beer either. But if their primary source of business is selling alcohol, you're not to go there. You're to submit to chemical testing, PBTs and ETGs when probation tells you to. They're going to have you test for the longest time 3 times a week, and then ultimately it will reduce to 2 times a week. They're recommending 60 days on the sober link going forward. I'm going to require 90 days. You're to attend 12-step meetings 3 times a week and provide written proof of attendance. You're to obtain an AANA sponsor. I know you said you have one, but You're to notify probation of that. You're to attend all substance abuse treatment in an approved facility and provide written proof of attendance. You're to attend the victim's impact panel. You're to attend and complete the armed specialty program. You have to report to sobriety court review hearings with me every 2 weeks. Obviously, in the off weeks, you'll be with the probation department reporting to them. They'll let you do a lot of that by Zoom. You're to obtain and maintain employment with proof provided to the probation department. You are to pay fines of $200, costs of $300, $75 victims' rights fee, $50 justice assessment. So your fines and costs are $625. There's a screening fee of $60 for $685. You have probation fees of $480, bringing your total to $1,165. You have sobriety court fees of $360, bringing your total here to $1,525. I'm going to order 72 days jail, and I am going to tell you how I'm going to break that down. You have, like I said, $1,520 in fines and costs, 72 days jail, credit 1. You're going to serve 6 on the court work program. There's a $35 a day charge for that. Your court work program fees will therefore be $210, so your total should be, and if you don't mind checking this, Heather or Amy, whoever's in there, the total should be $1,735. I'll let you set up terms of payment with probation. So I'm ordering 72 days jail, credit 1. I'm going to let you serve 6 on the court work program, like I said. I'm going to let you serve 5 by way of community. And I appreciate the fact that you're coming all the way from Farmington Hills, but that's just, I'm going to require that. 5 days of community service by May the 1. You're to serve 60 days jail beginning. You're going to give me a review hearing date, Amy and Heather, please, for about 2.5 months from now. You're coming back on that date. You're starting your 60 days. You will come in here for that review hearing. If you're compliant 100%, not 99, I'll probably not require you to serve any of that jail time. If there's any violation, you're going away. Do we understand one another? Can you guys give me a review hearing date? I don't care what day. In just the
Say
middle.
about 2.5 months, like the middle of April.
Yep.
We can do April 15th. I think that might be one of your sobriety court days, so.
We'll do it on April 15th then at 8:30 in the morning. I would be highly, highly, highly unlikely to give you jail if you're compliant, but it has to be 100%. If it's not, you're going to jail. Do we fully and completely understand one another? You have 21 days to appeal, 14 days to apply for a court-appointed lawyer for purposes of appeal. You could get a year if you violate. If you don't get through the program, you're likely going to do a year. I'm going to do this for you. There's something in my gut that tells me that you're going to be compliant. But I'm telling you, I don't want to come across as threat. You have no idea what kind of a break you're getting here today. And if you don't comply, you're not going to like me. You get through this program, you'll actually like me by the end. Not if you don't comply. I'm going to let probation set up terms of payment. I don't have to take any revocation act or immobilization action. The last was in 15. That's the other thing I'm looking at. First was 9, then 15, then 25. You know, and some will think it's too easy. Some will think I'm too. That's the price we. Good luck. I hope I don't have to send you to jail. Thank you very much.
Thank you.
All right. People against Jermaine Hall. Jermaine Sean Hall Jr. 25G306346A and 25G306346C. Mr. Hall.
James Schloff on behalf of Mr. Hall, 30720.
My apologies. I also have 25G 306346B. So I have A, B, and C. Two civil infractions sandwiched between or on the other end of a suspend in the middle. Your names? What are we doing on this, counsel?
I believe that we've come to a disposition, Your Honor.
You know, I don't have a problem with dismissing the suspend, but
Well, knocking it down to a no-ups.
no, I get that. But the defective equipment, I've asked these guys not to do this. It's 8 months old. I mean, they've been entered on his record. I'll tell you what, I'm not going to dismiss the defective equipment. If the prosecutor feels that strongly, he wants me to dismiss it, I'll just waive the fines on it, but I'm not going to dismiss.
Be fine, Judge.
If you plead to no ops, the possible penalties are up to 100 fines, 90 days jail. Costs are all of those. Do you understand that?
Yes, sir.
Are you going to stay with me now? You've been agitating me the way you don't show up in court. Now, you want to tick off judges. You keep doing this. You get what I'm saying?
Yes. I don't take it.
Well, you're trying to. Listen, let's cut it. And if you plead to that, I'm still going to pay the fines on the no ops. I'm sorry, you're going to still pay the fines on the no insurance. I'm not taking his plea on that. He's been in default on that since July. I will waive the fines and costs on the defective equipment because the prosecutor wanted me to dismiss it. I don't feel comfortable dismissing a ticket that's been outstanding for 8 months. And we'll go from there. So do you understand everything here, Mr. Hall? Did he sign an advice of rights form today? I don't think
I gave him his rights. Did you sign an advice of rights form?
No, sir.
I'm going to cover him with your verbal. You are presumed innocent. They have to prove you guilty beyond a reasonable doubt. You have the right to remain silent. You don't have to say anything. If you do say something in or out of court, whether orally or in writing, it can be used against you. If you plead guilty, you're waiving the presumption of innocence. You're waiving your right to a jury trial. You're waiving your right to a trial of any kind. You're waiving the requirement that they prove you guilty beyond a reasonable doubt. Do you understand all that?
Yes.
All right. So if you plead guilty, we're not going to have a trial. Do you understand that? Right? I don't want to confuse you.
You're pleading guilty to these charges that the court has mentioned. When you plead guilty, you give up the rights that the court has just told you. Because you're not going to have a trial. It makes sense that you're giving up your trial rights, correct?
Talk to me, Mr. Holm. You understand if you plead guilty, we're not going to have a trial, right? You know what a trial is, right? Okay, that's all right. You ever watch any of the movies on TV where they have juries on there and that's a trial? And the prosecutor has to prove the defendant guilty beyond a reasonable doubt. And if they don't, the defendant is acquitted. That's a trial. If you plead guilty, we're not going to have a trial. The case is resolved. We're not going to bring in jurors. We're not going to have me decide. We're not going to have anybody decide. I'm only going to decide what I'm going to sentence you to. That's it. Do you understand that?
Yes, I understand.
Okay. You fully understand everything I've said now. If not, no problem. Just tell me. I'll tell you again. We'll go over it again.
Yes, I understand.
Okay. You sure? All right. To the charge, no valid operator's license on person. How do you plead? On February 7 of 25, were you operating a motor vehicle in Gibraltar near Jefferson in Gibraltar at 10:27 p.m.?
Saying what?
Listen to my question. On February 7 of 2025, almost a year ago now. Remember I was just talking about not showing up? They think you were operating, were you operating a motor vehicle on Gibraltar Road near West Jefferson in the city of Gibraltar at 10:27 p.m.? Did you have a valid license with you at that time on your person?
My license wasn't bad. I had that.
Right. You had a license on your person maybe, but it wasn't valid. You agree with that, right?
Yes.
Are you on probation or parole right now?
Probation.
400 tickets.
Was he on probation in February of 25? You sure?
Yeah.
If you were on probation on any case on February 7 of 25 and you plead guilty here, this would be deemed a violation of that probation. That probation could be revoked. You could be incarcerated on that charge as a result of this plea and conviction. You understand that? Yes. All right. You still wish to plead guilty? Just asking. I'm not trying to trick you here. No, I'm just asking you. That's what I asked. You still want to plead guilty? This is no absent person. I'm not sending you to jail. Anybody force you to plead guilty?
No.
All right, I'm going to accept your plea to no ops, dismiss the suspend. I'm going to waive the fines and costs, but I'm not dismissing the defective equipment. He still owes money on the insurance. Counsel, tell me who's with you. Is Sarah Ann Levitt here?
She's the one that dropped me off and she's in the car.
Who is she? Is she going to let you apply the bond? Because I'm not going to be very patient with you any longer. If the bond's in her name, I want to make sure she's going to allow you to apply the bond. Otherwise, you're going to have a problem because I'm not giving you time to pay again. You guys posted 3,010% because I got tired of you not showing up 4 or 5 times. She posted it. I can't apply the bond when it's in her name. If it was in your name.
Take the money that was placed to the bond towards your fines and costs. But he needs,
Permission from Ms.
Oh, okay, yes, that's fine, you can take money.
Well, that's nice for you to say that. You're going to have to go get her in the courtroom right now, okay? I'll go on to another case. Teresa Lynn Riddle, 25T642922.
And Judge, we have Detective Driscoll. Sorry, I cannot speak.
Detective, come on in here, will you? And call in Mr. Bologna.
Yes, Judge. How are you this morning?
Not too bad. We'll see how this one goes. Your name, Detective?
Detective Sergeant Mark Driscoll with the Trent Police.
Yeah, call him. Your name, ma'am? Ma'am?
Oh, Teresa Bethel?
Your Honor, for the.
Your appearance.
For the record, just fluff 30720.
Thanks.
I'd like to call you and the prosecutor in.
Prosecutors and what Judge Hess.
I could start off perhaps without the prosecutor, if I may.
Yeah.
Your Honor, I know Miss Riddle from some previous representation. She had a felony in front of this court for a preliminary exam, got found over. And after that preliminary exam, I was assigned a representative. She discharged me. There was no problems with that. It happens. And she went through a number of attorneys after that. And today, lo and behold, I saw her here. And I was going to represent her. She informed me that she'd rather have another counsel.
Mr. Bologna, your name?
Anthony Blank at the City Trent, Your Honor.
All right. Well, I don't know what to say on this. You don't get to pick your own lawyer. What did Mr. Schloff do wrong?
No, it's just that he did not represent the.
Well, I don't know what that means. I mean, I don't know what that means. You got to be more specific. He's a good lawyer.
All right.
Turn that microphone toward her, will you please?
He just didn't, I wanted him to be aware of certain things and handle things as a certain way. And I just want to handle it without.
On the other case? Yes?
Felony case.
Has he done anything wrong on this case?
Well, I mean, it's still, he's got that previous record.
What record?
Well.
You don't have a felony record, do you? Or misdemeanor record? What record?
Just, I mean, I didn't like how the previous,
Ms. Riddle?
hearing.
Can I, I'm just gonna have a candid conversation. Mr. Bologna, your name?
Anthony Blank, City Trent.
Detective Driscoll, I got a disturbing call the other night about accusations that Ms. Riddle has levied against me.
Yes, Your Honor. If you need, for the record, I can send you a copy of.
Need it. I know.
Yeah,
I'll say it. I don't even know the lady. She was accusing me of sexually assaulting her, and she was accusing me and another judge of conspiring to hire a hitman to have her killed. I can still handle this case fairly. I think there's other issues going on. I'm ordering a competency exam on this. and I'm going to order it now, and I'm going to continue the bond, and we will have a competency exam, and that's it. I was like taken really aback. I mean, I've had accusations that are false levied against me in 32 years, but that's ridiculous. So, ma'am,
It was a tribute for the newspaper.
I think that you shouldn't get into the details at all.
competency exam is ordered. I'm going to keep you on the case. You don't have the right to hire and fire court-appointed lawyers. If you're not happy with Mr. Schloff, you're going to have to be more specific. I'm not prepared to discharge him now. We'll see how the competency results come back. And we will go from there. And competency exam ordered. We'll set this for arraignment and pretrial. I'm guessing that they're taking at least 2 months, right? So why don't we set this up for sometime in the middle of April? And
Will it be on a Thursday as well?
yes, and I'm not going to remove Mr. Schloff. You haven't given me any reason. I've been around Mr. Ma'am. I've been around Mr. Schloff enough in my career. I have a great deal of respect for him. I would find it hard to believe that he did anything wrong. And when we come back, if you still want him discharged, you're going to have to be a lot more specific about what he has done wrong in this case, okay? But I'm ordering a competency exam. You have to go down and get evaluated, okay? I think this is for your own good. We'll set it for ma'am.
You're gonna send me, I've already had, call our,
I can't hear you, ma'am. You got to talk into the microphone nice and loud.
I've already, worked with what I was trying to do was file charges with the Trenton Police Chief. And he has refused for the last 2 years to file any charges or complaints. And then when they arrested me and that chief spit.
All right. I don't want to hear it.
I'm gonna file that.
I don't want to hear it. I don't have anything to do with that. Listen. I'm going to send you for a competency exam. I think we can help you. Ma'am, do not argue with me, please. That's what I'm ordering. We're going to give her a review hearing date in the middle of April, and we will go from there.
She received a letter from
The Forensic Center. So we need to make sure, do you still live on Charlton Road, apartment 119?
I am, I'm almost into Trenton Tunnel. They're just.
Ma'am, I just need your address.
Yeah.
You live at 1795 Charlton Road, apartment 119.
My new address is general delivery because.
Ma'am, I can't tell the Forensic Center to send it to general delivery and have it gift to you. Tell
Judge,
me you're.
If I can
Well-
interrupt, she does not reside at 1795 any longer. She was evicted from that residence. She has a P.O. box in Trenton. I know she's moved from hotel to motel over the last several months.
What's her P.O. box?
Ms. Riddle, if you can provide that.
What is it?
248.
248?
Is there a specific?
So we'll send it to 248, but I hope you go and look at it every day, because don't come in here when you don't show up for the exam and tell me I never got it. I didn't check my P.O. box. I don't know what else to tell you. You got what I'm saying?
Is there a specific post office where that box is?
Just in regular post office.
It's in the city of Trenton, right?
Yeah, I'm sure.
Yeah, Trenton Post
I
Office.
just wanted to make sure.
So that's where we're going to send the mail. We're going to set a review hearing in the middle of April. When will that be, Heather or?
Judge, we could do either April 9th or April 23rd.
Let's set it for April 9th at 9:30 in the morning. You go down the hall, get your notice, but you have to show up for the forensic. I want you to listen to me very carefully. Sometimes things go awry in our life. We have problems. We're going to try to get you some help. Just let me try to help you, will you please? And I think you'll find out this will work better. Detective, if there's something else to add, I'll be glad to listen. I see no reason for me to recuse myself at this point. I think it's just,
Don't I ask you to recuse when I was in authority before, and,
you asked me to recuse myself?
Can you say before, during the pendency of this charge?
I don't think she's ever been.
It was when that girl, that she had 3 vicious, unleashed dogs.
Ma'am,
That attacked me.
ma'am.
And I asked you to recuse.
Well, okay.
that day.
I have to have a basis for it. I have to either be biased for you or against you. And ma'am, please don't interrupt me. You have a tendency to interrupt people. There's nothing here that makes me biased for you or against you. Okay? Your allegation's so ridiculous, it's laughable. I'm not getting into this anymore. Go down the hall, get your review hearing date. I'll address the issue with Mr. Schloff when you come back. You got to show up for your examination, and we'll let it play out. That's it. Have a good day.
Can I request the FOIA in the court hearing?
Request what?
The FOIA from that court hearing,
What court hearing?
the one where I asked you to recuse yourself.
Ma'am, I don't even know when it was. I don't remember. Well, then you request it, you pay for it, and we'll be glad to type the transcript up. I don't care if you did or not. I'm not biased for you. I'm not biased against you. This is the way I do my job every single day. I'm not going to hear it anymore. Back away from the podium, go to the exam, go down the hall, get your notice, and I'll address all these issues then. Thank you. Jermaine Sean Hall Jr., 25G 306 346 A, B, and C. Back away from the podium, Ms. Riddle. All right, come on up here, ma'am. Ms. Riddle, back away from the podium, ma'am. Now, don't make me do something I don't want to do. Back away. You go to state as a lawyer, detective. You know that?
Sometimes it's easier, Judge. I understand.
Oh, they think what I do is easier. Come on up here. I'm just kidding. Mr. Hall, your name again. Ma'am, your name? Are you Sarah Ann Levitt? Tell me that and respond to that. You have 3,010%. Are you going to let Mr. Hall apply this to these fines?
Sorry.
You posted a bond of $300. That means he has $270 to apply. I need your permission as to whether or not you're going to let us apply the bond to payment of fines and costs.
Yeah.
Okay, good enough. You're going to go down the hall and deal with them in a second. Let's sentence on the no ops. Anything, counsel?
Nothing more except he's been trying to clear up his record.
Anything, sir?
I'm trying to pay him a lot more, honestly.
100 fines, 100 costs, 75 victims' rights, $50 justice assessment, 3 1/4 or 60 days. You have a bond of 3,010%. By law, we keep 10%. 270 will apply. I'm going to give you until March the 1st to pay the other $55 on that. On the other case, I told you I'd waive the fines on the defective equipment, file A, I am. And on file C, you're to pay $50 per week. $50 per week, beginning March the 15th, okay?
Sir.
And if you don't have the money, you come talk to me in person on or before the due date, or if you know how to use Zoom, you call the court, say, can I jump on Zoom with the judge?
Calls the case, People versus Randall Laird. This is AG. This is AG.
Morning, Your Honor. Assistant Attorney General Doris Williams on behalf of the people.
Good morning, Your Honor. Assistant Public Defender Dottie Lebo on behalf of Mr. Laird, who I believe appears by Zoom. Mr. Laird, please state your name, sir.
Yes, sir. Randall Laird. I need a camera, sir. I'm working on it. I'm sorry. What are we doing?
In regard to requesting an adjournment, I did just receive full information on the potential offer this morning, which I'd like to review with Mr. Laird.
I put that on the page here, sir. 26. Yeah, so let's go that way. All right, probable cause conference in this case will be during February 26, 2026, 9 a.m. Bond continue.
Thank you, Your Honor.
Thank you.
Thank you. Case People versus Andrew Patton.
Oh, that was it, I guess.
Yeah, that was it. Unless you want me to do something else, but people normally don't. Thank you, sir. All right.
Good morning, Your Honor. Charlotte Steffen on behalf of Mr. Patton.
Mr. Patton, can you state your name, please?
Andrew Spencer Patton.
Thank you. What are we doing?
Your Honor, we have reached a resolution of this matter. Mr. Patton is signing the plea form and the advice of rights form. The people have offered to reduce this to the use of cocaine, a 1-year misdemeanor.
He's going to plead guilty to that charge.
Yes, he is, Your Honor.
All right, the plea form that I have in front of me now indicates that the defendant will be pleading guilty to the charge of use of cocaine, the 1-year offense. Upon a successful plea to that charge, count 1 would be dismissed.
That is correct.
That's the court's full understanding of the agreement. May I have it sworn?
Raise your right hand. You solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
State your name, please.
Andrew Spencer Patton.
Sir, it is this court's understanding that you're going to be pleading guilty to the charge of use of cocaine.
Yes, sir.
That's a misdemeanor punishable by up to 1 year in jail and a $1,000 fine plus court costs. You understand that?
Yes, Your Honor.
You understand also, sir, that while I'm taking your plea, I would not be your sentencing judge in this case.
Yes, Your Honor.
And that you would be sentenced before Judge Perry in the 15th District Court.
Yes, Your Honor.
Still wish to plead guilty?
Yes, Your Honor.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes, Your Honor.
You signed an advice of rights form, is that correct?
Yes, Your Honor.
Any question regarding any of those rights?
No, Your Honor.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights, which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
No, Your Honor.
Anybody promise you anything other than what's been stated here today on the record to get you to plead guilty?
No, Your Honor.
Anybody threaten you or coerce you?
No, Your Honor.
You're doing this voluntarily
Yes, Your Honor.
of your own free will
Yes, Your Honor.
because you believe that you're guilty?
Yes, Your Honor.
May 16, 2025, at the location of North Huron Street, City of Ann Arbor, Washington County, State of Michigan. Did you have cocaine in your possession?
Yes, Your Honor.
Had you used it?
Yes, Your Honor.
And did you know what you were using was cocaine?
Yes, Your Honor.
Sir, if I accept your plea between the time that I accept your plea and the time of sentencing, if you commit misconduct as defined by the Michigan court rules, you would not be entitled to withdraw your plea, and the court would not be bound by any sentence recommendation or evaluation. You understand that?
Yes.
Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
No.
And have I complied with the court?
Yes.
You have, Your Honor.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 15th District Court probation. Sentencing will be
February 27th at 8:30 before Judge Perry.
February 27th, 2026, 8:30
Your Honor, may I address that?
before Judge Perry, as to bond.
Thank you, Judge. Your Honor, Mr. Patton is in custody on a bond violation for failure to test. It's my understanding that he was reporting as directed, but didn't have the funds to test. He also believes there was some discussion at the time that the bond was set, indicating if he was not able to afford testing, that he would not be in violation. So we are respectfully asking if Your Honor would reinstate the bond. Thank you, Judge.
Any response from the people?
Here's the question.
Are you going to be able to test?
Yes, sir. I mean, I can't afford it, but I can test clean. I can't afford it.
Well, you're going to find a way to.
I can find a way
to test. Because if I let you out, we're going to end up in the same boat again. If you don't go over there and don't test.
I can go test. I can either pan out or do something to make that money up, but I can. Yes, sir.
I'll grant the motion for bond reduction. Previous bond is reinstated with
Thank you,
its
Your Honor.
conditions.
Thank you, Your Honor.
Thank you. This is what I need to do. CC order. Just want to put back to work. Court does call the case People versus Michael Padola. Yeah, I see him. Here's his attorney. Who's his attorney? Mr. Bennett? Really? Mr. Bennett? Sir, state your name.
Michael Bedola.
I'm gonna pass your case. We gotta wait for your attorney to show up.
Okay.
He's on the Zoom screen, but not responding. All right, I'll pass that case. Court does call the case of People versus Cadena, so.
Your Honor, I'm sorry, did you call Bedola? No, you didn't.
Good morning, Your Honor. Christina Saxon on behalf of Mr. South. Please state your full name for the court. Kadena Gale Self.
Thank you. You're requesting an adjournment.
Yes, Your Honor.
You're waiting. You just got appointed. You're waiting video discovery.
Correct.
Is that on its way?
We have it, Your Honor, so it should be.
Probable cause conference will be adjourned then to February 12th.
Your Honor, I'd like to make a bond modification motion.
February 12th, 2026, 9 a.m. Yes, it's the bond.
Your Honor, Ms. Self is being held on $1,000 cash bond. I'm asking for a reduction to a personal bond. It's reported to me that she and the alleged victim do not reside together. He has a different address, so she should be able to return home. And or may not be able to see. She does have a cast on that she will need to go to a physician to address, and being incarcerated, I'm afraid that she won't be able to do that to get it off in a timely manner.
Response.
Your Honor, at this point, I would object. On our bond, we requested 25,000 cash period. This involved Ms. Self stabbing the victim in the shoulder with a screwdriver. He had 5 puncture wounds that officers saw. She was also very irate and aggressive at the scene when officers arrived and were berating the victim, and then had to be carried to his car. So I expect that this could potentially be other charges in the future for RNO, but at this point, I would object.
Anything else?
Yeah, I would just say that it was a highly intense situation, and berating, calling someone names does not rise to the level of incarceration. I believe, or additional charges. Calling someone names isn't enough.
Well, the
But for this,
stabbing with a screwdriver, that would do it, wouldn't it? You don't need to say anything. Motion for bond reduction denied. Bond will continue. Thank you. She's lucky I won't raise it at this point. Court calls case People versus Edna Grima.
Good morning, Honor. Charlotte Steffen on behalf of Ms. Grima.
Good morning, sir.
Good morning.
Your Honor, we're requesting an adjournment for discovery.
The adjournment. Have you seen the progress report?
Yes, I reviewed it with my client this morning, Your Honor.
Why do I have cocaine showing up in her system?
Because, sir, when they test over there, they don't do it the levels. So I've been getting high for 48 years.
What?
Yeah. And so even though it was like, I think the last time was like New Year's Eve or January 5th, one of the other. but you don't show levels, so you don't show it going down, down, down. And therefore, if you got cocaine in your system, you just got cocaine in your system. That's how it is. But that's not okay because it could be in my system for a long, long time, even though I don't get high.
Okay, so just so I'm clear what you're telling me,
Yes.
that on January 5th, you tested positive for cocaine. And that was just,
And I didn't
that was just
expect,
something in
it
your
should
system.
not have been.
It shouldn't have been there.
Right.
It's just stuck in your
But you
system.
guys don't do
And
it
then-
by levels.
What?
But you don't test it by levels to see if it's going further and further.
Okay, so then the next time you're supposed to test, you missed the test.
Huh?
Then you missed the test.
Oh, I didn't have $12.
Okay. And then the next test, almost 2 weeks later, you're testing and you test positive for cocaine. And so, hold on before you, because I want to make sure I've got your story. And so you're telling me that the second test for cocaine was really the same as the first test because it's just stuck in your system because you've been doing cocaine forever.
What I'm
I don't
saying,
know who the heck you are, but if you start yelling in my courtroom, you're going to be going with her.
okay, this what happened on the 5th, to be honest.
What? What happened on the 5th?
I said that, wait, what happened? Let me think.
I don't know. Go ahead, think about it.
Right. What I'm saying is on the 5th, I was dirty. I had used like not that far from there. But I was scared to say so because I was scared to say so. So then the next time I didn't have the $12. And the next time
So
it was
hold on.
still
That's what I was getting at before your band started yelling out from there.
my sister. She here
Okay,
from
all right, but
out of town.
so you're telling me
Mhm.
this test that showed up positive, you didn't use cocaine,
Which one?
the 20th,
The 20.
last
no,
test.
No, I had.
You had
Since
not
the
used
5th.
any cocaine,
No.
even though you've been using it for years.
Right. Right. It should have been clean. I'm saying, I don't understand why it was dirty. But the problem is this, sir. You guys don't check the levels. So you,
Oh,
I
can check levels.
I wish
but
y'all
not-
would.
But, well, I can get the levels.
Okay.
That's not a big deal.
Okay.
The problem is because you missed the test,
Uh-huh.
if you did a little bit of cocaine, it'll look like it's going down, but you didn't use cocaine still.
Oh.
You should not be testing positive for cocaine 2 weeks later. That's the bottom line.
So now.
Grant an adjournment in this matter to February 5th, 2026, 9 a.m. That's 1 week out.
Your Honor,
You're not available that day?
correct.
That's fine. I'll set it into 12. At this point, the defendant's bond's revoked. She's remanded.
Damn.
What'd you say?
Excuse me. I was saying my
You
sister.
know, you need to take yourself on out. What? What last one? Oh, was it? Did you know something?
Want me to repeat it?
No, that was. You don't get that response. No, she's what? You don't talk to me about that? No, okay. Court does call the case of People versus Terry Probst.
Michael Gaddy, Assistant Public Defender, on behalf of Mr. Probst, who's making his way into the courtroom, I would assume.
Well, where is he?
Is that?
Evan is custody.
He is in custody, Judge.
Oh,
Just give that back to me. Yeah.
we'll pass it.
Okay.
Court does call the case versus Quan Patterson.
Freeman Cook.
Cal Kavalowski for the people, Your Honor.
What, who's that?
That's Mr. Pro.
Oh, I'll just take him if you got it. All right, back on the probes matter.
Morning, Your Honor. Freeman Cook.
Okay, sign that. Michael Gaddius, public defender on behalf of Mr. Probst, Your Honor. State your name.
What are we doing? Thank you, sir.
Your Honor, these are going to be waivers. I have gone over his rights. He's executing the form now. I've gone over
Sir,
with Mr. Probst.
You're waiving your right to a preliminary examination?
Yes, sir.
You understand that that's a proceeding where the people would have to show by probable cause that's alleged to have committed it, you committed it.
Yes, sir.
You understand you'll not have that hearing, and you'll proceed to circuit court for further
Yes, sir.
resolution. People also waive their right?
Yes, Your Honor. There was an offer I can put down on the record.
Yes, go ahead.
The offer was leading to the filing 1391, which for dismissal of filing of that.
All right, good.
That is correct, Judge.
Preliminary examination having been waived in both of these matters. Defendant is bound over to circuit court.
Your Honor, in terms of arraignment, we'd waive reading, stand mute in the charge.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea. Pretrial will be set for February 11, 2026, 1:30, Judge Conlon.
Your Honor, if I could be heard on bond.
Yes.
Your Honor, I've had a chance to speak with Mr. Probst about this. I've reviewed the file. Mr. Probst was remanded at his last probable cause conference. He had missed some tests and had tested positive. The positive tests, looking at the violation, were from when he was first arrested. He reports he got a personal bond sometime around December 29th. He the missed tests he reports resulted from a stay in the Wayne County Jail where he was, obviously unable to test. He then reports having gone to community corrections. They indicated that they did not have any record of him needing to be there, and that's why he didn't test on the 29th. I'd ask the court to release him. He does report that he does have a place to stay in gainful employment. I have reached out to he gave me a number. I've reached out to the employer. They haven't gotten back to me yet. So, but that's kind of where things stand, Judge. He reports that he would test regularly in this matter.
That's not what my file reflects, his rendition of things. But most for bond reduction tonight, bond will continue. We'll bring it up.
Thank you, Judge.
Court calls case People versus Quan Patterson.
Cal Kavalowski for the people.
Is that Mr. Goldstein, Your Honor?
Patterson.
No.
Mr. Bullock.
Oh,
Your Honor,
okay, then.
Mr. Kilowatt is on Zoom in another court,
Who?
or I'm sorry, Mr. Goldstein is, sorry. He's trying to wrap it up, so he's not gonna be able to come in for a couple of seconds.
Is this Klein here?
Yeah.
Oh, okay.
Client is here. And I don't have stage right.
Why are you sending as the messenger? You wouldn't even stand up at the beginning of the docket. Now you're delivering message. No, I don't want to talk to you. Bye. Court calls the case of the People versus Bradley Potter.
Alan Zend on behalf of the people.
Ron Brown Train on behalf of Mr. Potter. Mr. Goldstein standing in for Mr. Fikowski.
Seriously? Okay, we can't, no.
You want me to go get him?
The one you were delivering messages for.
Tell him Bradley Potter's up.
Bradley.
Sorry.
Your name, sir? Bradley Potter. Thank you. None of this is your fault. This is.
Goldstein standing in for Mr. Fikowski.
Do we know what they're doing?
Setting exams.
Setting it for exams?
Both of them. Mine
Okay,
too.
so based upon your knowledge, the discovery is complete?
That's my information.
And so you want your matter set for exam? Is that what you're
Yes,
talking-
sir.
All right, very good. Would the people have their witnesses available the 10th? preliminary examination will be set February 10th, 2026, 9 a.m. before Judge Garwood.
Hey, I just said it for you.
Okay. Bond will continue.
It's February 10th. Judge Garwood.
Thank you. I'll tell Jim. And, all right, thank you, sir. We already took care of it after we got the message from your messenger, Cannon.
She couldn't do the waiver of.
That's what I was saying, but she was delivering messages for people. I don't know what her deal is.
Judge, I approach in a related matter to this.
To which one?
Mr. Popowski.
Oh, sure.
I'm standing in for him today, Your Honor.
Or does recall the case of People versus Quan Patterson. Did I finish Quan? No. Quan Patterson.
David I. Goldstein, appearing on behalf of the defendant.
What's your name, sir?
Quan Patterson.
Thank you.
Your Honor, we do have all the discovery, including the videos, and we're asking the matter be set for free.
People have their witnesses available the March 10th. Yeah, that's what I said. Is there a problem with that?
I hear it most judge.
Your Honor, if I could address Bond.
Go ahead.
If I can address Bond real quick. My client, the magistrate, for whatever reason, saw fit to place a tether on my client, a GPS tether. It's not a curfew. We're not sure why exactly. He wasn't ordered to do any testing. I've known Mr. Patterson for a number of years. He's a lifelong resident of this county. He is not a risk of flight. He works in this county. He lives in this county. He has family in this county. So we're not sure why the magistrate, I wasn't present at the arraignment, Your Honor. Not sure why he did it, but we're asking the
question. Do you have anything else pending?
No, Your Honor. No. And all I can say about this particular case, Your Honor, is I think whoever the judge at the prelim is going to find the video very interesting.
Okay, with the understanding that there's been a change in circumstance on this, I'll grant the request to remove the GPS tether. So we'll prepare an order and let them know so you can get that removed even before you leave here. Just go over. Okay. I'll set preliminary examination in this matter March 10th, 2026, 9 a.m. before Judge Garwood. Is bond and its monetary amount will continue without fee.
Thank you.
Thank you. Court calls case People versus John Marks.
David I. Goldstein, appearing on behalf of the defendant.
Your name? John Marks. Thank you.
We're setting this matter for exam, Your Honor. I do have discovery.
People have their witnesses available March 10th.
We'll do our best, Your Honor.
Preliminary examination in person, March 10th, 2026, 9 a.m. before Judge Washington.
Thank you, Your Honor.
Thank you. Bond continue. Calls case People versus Javante Cadell.
Morning, I'm Rob Dixon on behalf of Mr. Cadell. Javante, would you state your name on the podium? My name is Javante Cadell. Judge, we're asking to set this matter for exam.
Discovery is complete.
Yes, sure.
People have their witnesses available February 10th.
Judge, may I address bond?
Preliminary examination in person will be set February 10th, 2026, 9 a.m. before Judge Fresh Hour. Yes, to bond.
Judge, this young man's 18. He has no criminal record, juvenile record. It's my understanding he was living at Ozone, who was trying to place him with his own apartment. I understand there's a $10,000 bond because he missed a court date. He did not have a ride at that time. What I'm asking the court is, I've spoken to this young man. He promises to appear for all future court hearings. We would like to get back to the Ozone so he doesn't lose his place as far as getting a placement, and he can be gainfully employed. We would just ask the court to set a PR bond in this matter.
Any response from the people?
Your Honor, I'll leave it to the court's discretion, but if it helps the court decision making at all, the co-defendant's case that was set for a claim on Tuesday got dismissed because we were unable to proceed at that time.
Got it. How do you come back into custody?
Were you arrested or did you?
I was arrested, sir. My caseworker was supposed to call due to the weather conditions. He said he called, but I guess, but I was picked up, sir.
What were you doing when you were picked up?
Trying to get to one of my friends' house. But sir, I tried to make it to court. The weather conditions was hard. I ain't have a phone. It was cold. My phone died, sir. And I tried to my my caseworker, he tried to help me too, make sure I made it to court, but he couldn't help me.
You grew up in Michigan?
You said what, sir?
Did you grow up in Michigan?
Yes, sir.
You're going to appear for our future.
If it was too cold, then we're getting soft.
Nah, it wasn't even just that. I didn't have the right clothing either, sir. And I was building
I got you.
Through the distance.
I got you. Well, reinstate his previous bond. I'll grant the reduction. Reinstate his previous bond, but you better show up on the 10th. You hear me?
Yes, sir.
You got to start out walking on the 9th. You better show up on the 10th.
Yes, sir.
You call me, okay?
No, sir.
Let me just see real quick.
Those previous bonds stated.
See right away here, boss.
Court does call the case People versus Gary Coward.
Morning again, Your Honor, Honorable Court, David Williams, on behalf of Gary Coward.
Gary Coward.
Thank you. Your Honor, myself and Mr. Chablowski are trying to resolve it at the district court level. If I can come back on the 12th, I'm back here again, Judge.
Probable cause conference without objection will be adjourned February 12th, 2026, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you. Text you. Court calls the case of the People versus Caitlin Quinn.
You were right. I was wrong. Morning, Your Honor. For the record, Brian Stacy, P33014. State your name.
Caitlin Quinn.
All right, I have before me a plea form that indicates that she's going to be pleading guilty to the charge of use of methamphetamine, the 1-year offense. Upon her successful plea to that charge, count 1 would be dismissed. That's, of course, full understanding of the.
That's accurate, Judge. I have had an opportunity to explain to my client her rights in detail. I believe she understands them, and at this time, knowingly, voluntarily waived them, and lay a factual basis to the added count.
May I have her sworn?
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
State your name, please.
Caitlin Quinn.
Ma'am, it is this court's understanding that you're going to be pleading guilty to the charge of use of methamphetamine. That is a misdemeanor punishable by up to 1 year incarceration and $2,000 fine plus court costs. You understand that?
Yes, Your Honor.
All right. In understanding that, you still wish to plead guilty?
Yes, Your Honor.
And to that charge, how do you plead?
Guilty. Guilty, Your Honor.
Now, you understand that by pleading guilty, you will not have a trial of any kind.
Yes, Your Honor.
You signed an advice of rights form, is that correct? Or had one signed on your behalf?
Yep. Yes, Your Honor. Yep.
All right. Any question regarding any of those rights?
No, Your Honor.
You understand you're giving up those rights on that form,
Yes, Your Honor.
particularly the rights contained in paragraph 5. If you look on the podium, you'll see a copy of the advice of rights. Understand you're giving up those rights as well as all the rights that are contained on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
No.
All right. Has anybody promised you anything other than what's been stated here today to get you to plead?
No, Your Honor.
Anybody threaten you or coerce you?
No, Your Honor.
You're doing this voluntarily?
Yes, Your Honor.
and of your own free will,
Yes,
and because you believe that you are indeed guilty of this offense?
yes, Your Honor.
On the date of September 4th, 2025, Washtenaw Hogback Road, Pittsfield Township, Washtenaw County, State of Michigan, did you have methamphetamine in your possession?
Yes, I did, Your Honor.
Did you use it?
I did, Your Honor.
And did you know what you were using was methamphetamine?
Yes, I did, Your Honor.
All right. Ma'am, if I accept your plea, I have to advise you that if you commit misconduct as defined by the Michigan court rules, between the time of my acceptance of your plea and the time of sentencing, you would not be entitled to withdraw your plea, and the court would not be bound by any sentence recommendation or evaluation. You understand that?
Yes, Your Honor.
All right. Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
Defense is not aware of any, Judge.
All right. And have I complied with the court rule?
And defense is satisfied, Your Honor.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14A1. Probation sentencing will be set for February 11th, 2026, 9 a.m. That's before me.
And that's here, Judge, correct?
That is correct.
And Your Honor, can I address bond?
Briefly.
Judge, briefly, my client has no prior offenses. The test did come back, the one that she appealed, and it showed the progress report. It said victims report negative for fentanyl. And I think that was one of the issues that the court kept her. And I think she would acknowledge that she did use cocaine after.
No, well, go ahead, counsel.
No, and I think she would acknowledge that she used cocaine after being placed on bond initially when you put her in jail, since she's been in jail since January 8th. And she also, Judge, has been diagnosed. She was taken to the hospital while in custody for gallstones. Apparently she does not have any gallstones, but she has blood in her urine, and the doctors believe that she has kidney stones. So she does need medical attention. And she was hoping her daughter's 15 years old, she's homeschooled, and her grandmother is 86 years old, and she's been diagnosed with Alzheimer's, and she was hoping to move in with her, and her daughter would be with her and to help take care of her grandmother. Her mother, I believe, is.
Are you going to be able to test clean if I let you out?
Yes, sir. I've learned my lesson, Your Honor.
I'll reinstate her previous bond with the testing, and so she'll be released on PR.
Thank you very much for your consideration today, Judge. You have a good day.
You do the same.
Thank you.
Court does call the case People versus Jennifer Burnside.
The people.
Morning, Your Honor. Jason Hagelthorne on behalf of defendant Jennifer Bernstein, who's present, standing.
Morning,
by.
Your Honor.
Good morning. Your name?
Jennifer Burnside.
All right. I have before me a plea form that indicates that the defendant will be pleading guilty to the charge of operating while intoxicated, second offense, the 1 year. On her successful plea to that charge, counts 1 and 2 would be dismissed. Defendant agrees to enroll and participate in the 14A Sobriety Court. There is also a sentence agreement. Well, it just says the 14A, it says A3, but it's 14A Sobriety Court. Defendant has been accepted as of January 29, 2026. And there is a sentencing judge waiver checked off. That is the court's full understanding of the agreement.
Yes, Your Honor.
Yes.
May I have her sworn?
Raise your right hand. Do you solemnly swear to affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Say your name, please.
Jennifer Burnside.
All right, ma'am, it is this court's understanding that you are going to be pleading guilty to the charge of operating while intoxicated, second offense. That is a misdemeanor punishable by up to 1 year incarceration, up to $1,000 fine plus court costs. The court could order any rehabilitative services or community service to court teams necessary. The court could also order your vehicle forfeited or could order your vehicle immobilized, could order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand all of that?
I do, Your Honor.
You also understand, ma'am, that while I'm taking your plea, I would not be your sentencing judge and you would be sentenced before Judge Freshour in the 14A3 District Court. You understand that?
I do, Your Honor.
Still wish to plead guilty?
I do.
And to that charge, how do you plead?
Guilty?
Now, you understand by pleading guilty, you'll not have a trial of any kind.
Yes, I do.
You signed an advice of rights form, is that correct?
I did, Your Honor.
Any question regarding any of those rights?
No.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights, which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
I do, Your Honor.
You understand you're giving up your right to appeal of right.
I do.
Are you on probation or parole?
No, I am not.
Has anybody promised you anything other than what's been stated here today to get you to plead? Anybody threaten you or coerce you? You're doing this voluntarily
I am, Your Honor.
of your own free will?
Yes.
And because you believe that you are indeed guilty of this offense?
Yes, Your Honor.
April 10th, 2025, at the location of I-94 near Freer Road in Sylvan Township, Washtenaw County, State of Michigan, were you operating a motor vehicle?
I was.
Prior to operating that motor vehicle, you consumed, I guess, alcohol and cocaine
I did, Your Honor.
and THC also.
Yes,
Is that correct?
Yes.
All right. Were you stopped by the police?
Yes, I was.
All right. Why'd they stop you?
My turn signal was burned out when I went to go get on the highway.
All right. Were you arrested?
I was, Your Honor.
Were you taken to the hospital for a blood draw?
I was, Your Honor.
And what were the results of that blood draw regarding alcohol?
0.97, 0.097.
0.097. All right. Did it also show the presence of cocaine or its derivatives as well as THC and or its derivatives?
Yes, Your Honor.
All right. Do you have any reason to dispute those blood test results?
No, Your Honor.
All right. And ma'am, had you previously been convicted of operating while intoxicated on or about June 25th, 2023 in the 53rd District Court and operating while impaired on or about February 25th, 2006 in Farmington Hills District Court?
Yes, Your Honor.
All right. Ma'am, if I accept your plea, I do have to advise you if you commit misconduct between the time I accept your plea and the time of sentencing in this matter, that you would not be entitled to withdraw your plea and the court would no longer be bound by any sentence evaluation or recommendation. You understand that?
Yes, Your Honor.
All right. Is counsel aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
No. All right. And have I complied with the court?
Yes, Your Honor.
All right. Court will accept the defendant's plea of guilty to count 3, excuse me. Counts 1 and 2 are dismissed. Pre-sentence investigation and report is ordered at 14A3. Probation. Sentencing in this matter will be March 9th, 2026, 9 a.m. before Judge Freshour. Bond will continue.
Your Honor, I did have one request renewed from the last time we were here. Ms. Burnside has a pretty severe cut. I know the probation, the testing facility, Keith over there had checked it. He has recommended her, and I believe he's going to accompany her to medical for that. They did switch the leg, but based on that, would the court be willing to transfer to the sober link and a release of that tether?
Response from the people.
Judge, we'd ask, being a photo manager in the Sobriety Court, we'd ask that the tether remain. If the court is willing, Mr. Heaton did give us a possible sentencing date of February 12th, and then Judge Freshour.
That date can be moved up. I'm not moving it up because I don't have a date.
Fair enough.
So you guys can do that, and if you can get it moved up, then that's fine, and I'm not going to remove the tether. Her bond will continue as is. Thank you.
Thank you, Your Honor.
I just need a form on that.
Yeah, okay.
Court does call the case People versus Marquetta Clement.
People.
Good morning, Your Honor. Assistant Public Defender Alexis Erbs with and on behalf of Ms. Clements, who's approaching. Can you please state your name for the record?
Marquetta Clements.
Thank you. You're requesting an adjournment?
Yes, Your Honor, to engage in some plea discussions, and I'd like to address bond when appropriate.
Probable cause conference will be adjourned February 12th, 2026, 9 a.m. As to bond.
Thank you, Your Honor. Ms. Clements is in custody based on a prior failure to appear at a probable cause conference on September 11th. It's my understanding that after this alleged incident took place, she was hospitalized at St. Joe's, and then St. Joe's transferred her to Stonecrest, and she was in Stonecrest from September 9th to September 26th. She was suffering from long-term memory loss. She had a concussion, and she was having some other mental health issues. I did try reaching out to both of the facilities. I sent releases of information to both. I haven't gotten any records back at this time. But once she was released from Stonecrest, she was working with leaf harm reduction. She can either stay with a friend in Ann Arbor, Your Honor, or she can stay at the Delana. She does provide me this address. And
How'd she come back into custody?
What you brought back?
Officer just took me off the bus, no reason. I wasn't in no trouble.
So, Your Honor, I believe in that.
He just came on the bus and grabbed you?
Asked Officer Lawrence, he did.
Because he knew you had a warrant.
He knew I had a warrant, but I didn't know I had a warrant at the time.
So, Your Honor, with that, I would say that there was no new charges when she was brought into custody. It was just officer recognition and being aware that she had the warrant, so they brought her in on the warrant. Like I said, Your Honor, I'm still waiting back on any of those records, but at this
So I
time,
don't have any medical to verify what you're saying, and she was gone for about 4 months.
yes, Your Honor, but I'm hoping those records will be here very soon. Like I said, I sent releases of information to both
So
St.
those
Joe's.
records aren't going to explain the 4 months. No answer needed. I don't need a response. Motion for bond reduction denied. Bond voted. Thank you. Court calls case People versus Abdul Latif. You know what? You keep talking. You want me to op it? Oh, give me the file. She wants to be smart. You can just let her know her bonds revoked. Mark the file.
Thank you, Your Honor.
The court calls case People versus Johnny Payne.
You're ready to talk to the people?
Morning, Your Honor. Michael Gaddy, Assistant Public Defender on behalf of Mr. Payne, Your Honor.
Her name, sir?
Johnny Charles Payne.
Your Honor, this is a matter we have reached a resolution. Looking for the paperwork now. I just had in my hands. Here it is. Of use of a controlled substance. I have him executing the plea form and the advice of rights. Now, I have gone over his rights. I have gone over his rights with him. Get it. And explained to him that all those rights. Your Honor, this is, I've seen a picture of the analysis. I don't have the report. I don't know that the labs have gone to the crime lab. I've explained that to Mr. Payne. He still wishes to issue a plea, enter a plea, if I may approach.
You may.
He is on parole, Your Honor. I've explained to him.
I'll get to it. Thank you. The plea form that the court has in its hands indicates that the defendant's going to be pleading guilty to an added count 2 of use of methamphetamine, that the 1-year offense. Upon a successful plea to that charge, count 1, the possession charge would be dismissed. There is prosecutor and defendants agree to a sentence of time served. However, I would indicate that taking the plea, I could not find the sentencing judge to that recommendation. And that, sir?
I do, Your Honor.
All right. May I have him sworn?
You solemnly swear to affirm the testimony you're about to give be the truth, the whole truth.
It is this court to understand you're going to be pleading guilty to the charge of use of methamphetamine. That is a misdemeanor punishable by up to 1 year incarceration, a $2,000 fine plus court costs. Do you understand that, sir?
I do.
You understand also that while I'm taking your plea, I would not be your sentencing judge and you would be sentenced before Judge Perry in the 15th District Court.
I do.
Still wish to plead guilty?
I do, Your Honor.
And to that charge, how do you plead?
I do plead guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind, any of those rights?
No.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights contained on that form.
I do, Your Honor.
You understand you're giving up your right to appeal of right?
Yes.
Are you on probation?
No, sir.
Are you on parole?
I am.
You understand that your entry of a plea in this case could be a violation of that parole?
I do.
You understand that as such, you could be sent back to do the remainder of your term?
I do.
All right. Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
They have not.
Has anybody threatened you or coerced you?
No, sir.
You're doing this voluntarily?
I am.
Of your own free will?
I am.
And also because you believe that you're guilty?
I do.
All right. On the date of December 12th, 2025, location of Barton Drive near Pontiac Street, City of Ann Arbor, Washtenaw County, State of Michigan, did you have methamphetamine in your possession?
I did.
Had you used it?
I had.
And did you know what you were using was methamphetamine?
I did.
All right. Sir, I do have by the Michigan court rules that you would not be entitled to withdraw your plea and the court would not be bound by any sentence recommendation or evaluation. You understand that?
Yes, Your Honor.
All right. Counsel aware of any other promises, threats, or other inducements which have led to this plea?
Defense is not, Judge.
All right. And have I complied with the court rule?
Yes, Your Honor.
Defense is satisfied the court has complied with the court.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. The pre-sentence investigation and report is ordered at 15th District Court probation. Sentencing in this matter will be February 27th, 2026, 8:30 before Judge Perry. My bond will continue. Thank you. Thank you, sir.
Thank you, Your Honor.
You're welcome, sir. Court calls case of the people versus Jessica Briscalia.
Good morning, Your Honor. Assistant Public Defender Alexis Earps with and on behalf Ms. Brosgala, who I believe should be appearing on Zoom.
Gala.
Okay. Hi. Can you hear me?
Yeah, we can hear you.
Okay. Jessica Bruscala.
Your Honor, we'd be requesting an adjournment this time. There's some more.
She's going to need to, let me just stop you. She's going to need to appear in person. We've had a problem with this defendant. She was smoking.
That wasn't me.
Folks, my staff has reported that was you. And it appeared as though you were having sex on the screen.
No.
Well, it was interesting. The reason I took a break was to go back and look at the video. And my staff reported it to me, and it did appear that that's what was occurring. To next week, the 5th, you'll have to appear in person, ma'am.
Okay.
That way we can assure you're not smoking and not having sex while you're in court. Thank you. Bond will continue.
Understood, Your Honor. Thank you.
Wow.
Yeah. Wow. You should see the video. All right. Thank you. Mute her and get her out of my court. Okay, it really wasn't all that exciting. I just we're so ready.
I mean, to be fair, it really wasn't all that exciting. It was more, you know, even if she wasn't, at this point, it's like, there should never even be the pronouncement of the question of like, was she or wasn't she? Because she was supposed to be on Zoom in court, and as I stated in the chat earlier, when you're on Zoom in court, you're on a big screen TV behind the judge that's facing the court gallery. Literally everybody in the court gallery can see you while you're in Zoom on court. It's not just a thing between you and the judge that's an intimate one-on-one. No. You're literally out in public. You're live on YouTube in many cases. Ladies and gentlemen, wake up. Understand what you're doing when you're in court, on Zoom. Act like you're actually in court, in the court gallery, like we do here every single night, where we try to be respectful as much as possible. and we comment about the court cases of the day. Come on by here. I do this every single night. Same Wolf time, same Wolf channel, 8 p.m. Eastern, 9 p.m. Wait, no, I got that backwards. 8 p.m. Central, 9 p.m. Eastern. Thank you all for showing up. I definitely need to give a couple of shout outs to some very important people who gave generous contributions throughout the course of the stream. Gen X, Donald, thank you so very much for your contributions. I am your Lone Wolf Usul. I'm your curator for these here videos. I'm your humble host for these here get-togethers every single night of the week and on the weekend. I'll see you next time. Ladies and gentlemen, I am out. No, we don't want no hollaback girl. No. No hollaback girl.